defendant filing a notice of self-defense before trial, and then at the charge conference agreeing to instructions on lesser included offenses like heat of passion, manslaughter, I just think it's unfair to say that this client had no interest in raising self-defense or that he knowingly withdrew that. I think he was misinformed that he believed that he could not assert a reasonable doubt defense on every element and that he was being forced to choose. And so that waiver, Your Honor put it as an excellent point. He was not told that he wouldn't be prejudiced by asserting self-defense. So unless the court has any further questions, we'd ask the court to order a new trial for Mr. Williams.
Let me ask you this. The jury heard, it's unusual this case that we've got an 8.5 minute conversation, 911, on one of the person's phones that went from start to finish, correct?
Correct.
Jury heard that twice, both during the state's presentation, and then they asked to rehear the entire 8.5 minutes again.
Correct.
Is there any really dispute with that type of evidence on what happened? And couldn't the jury hear it for themselves twice and then reconcile for themselves whatever?
I think there were some discrepancies between what the state alleged occurred in terms of maybe who the initial aggressor was, but certain statements on the call, like "I'll goddamn kill you" and shots being fired, those things can't be disputed. But I think the problem—
And neither can "please don't kill me," "please don't shoot me."
Yeah, I mean, clearly I think there are factual discrepancies here, but I think the jury wasn't given the legal tools, and really it's not really fair to call this a heat of passion situation, because it's not like he was provoked, like he was angry. It's just this was self-defense or imperfect self-defense, and the jury was just not— they were told that that wasn't even a permissible verdict in the case. So I'm not sure if that quite answers your question, but I mean, I think factually they were given what they needed, but legally they were not given the tools that they needed to resolve it properly. Thank you.
Thank you. Thank you very much. All right, the case is submitted. We'd like to thank counsel for their arguments, and at this point, we will conclude this matter, and we have another one on the docket, so we'll give you a few minutes to close. Thank you. Mr. Sawyer, I think we're going to just remain here, and we will have the next parties to come up for the next argument. Just remain at ease for a moment. You can go ahead and put us at ease. Good to stay. Okay.
Thank you. Appreciate you.
Well, we're trying to move it.
You're in fact doing that. I guess we got started early though.
on Jessica Black's recantation. Mr. Vlahos will address defendant's claims of newly discovered evidence and ineffective assistance of counsel. The state respectfully asks for 5 minutes in rebuttal. In 2004 and 2005, defendants were convicted for the murder of 61-year-old Nathaniel Jones, which occurred when Mr. Jones was brutally beaten while unloading groceries from his car outside of his home in Winston-Salem, North Carolina. More than 20 years later, after defendants' convictions were affirmed on direct appeal, after 3 of the 4 defendants filed previous motions for post-conviction relief, and after 3 Superior Court judges unanimously ruled that defendants failed to demonstrate they were actually innocent of the crime, a single Superior Court judge in August of 2025 ruled that defendants were entitled to relief on their 2023 post-conviction claims of newly discovered evidence, recantation evidence, and ineffective assistance of trial counsel. This was error. Further compounding the error, the trial court, rather than ordering new trials, which was the only form of appropriate relief available to the defendant's 2023 MAR claims, ordered a drastic remedy that was not authorized by North Carolina law: dismissal of all of the charges with prejudice. By granting this drastic remedy, the trial court exceeded its authority and interfered with the elected district attorney's constitutional role and prosecutorial discretion.
But doesn't the statute give this authority to that single Superior Court judge to make a determination both on the motion for appropriate relief and then also the discretion to determine what the appropriate remedy is?
Respectfully, no, Your Honor. The state's position is that the mere fact that NCGS 15A 14.7 identifies one potential form of relief in the MAR context of being dismissal of charges does not mean that is an appropriate form of relief, regardless of the nature of the underlying claim presented in an MAR. And I think there's several arguments supporting this. First is the fact that when the General Assembly enacted the MAR statutes in 1977, they made abundantly clear that the MAR statute was not to provide any kind of new procedural, no new substantive remedy, no new substantive rights for defendants. Instead, the MAR statute constitutes a procedural mechanism for defendants to raise claims in a post-conviction context when those claims already independently exist. That is supported by NCGS 15A 14.12 as well as NCGS 15A 14.11, both about which talk, and even if you look at the context of when the General Assembly enacted the MAR statute, before we had motions for appropriate relief in North Carolina, defendants had to identify the form of relief they were seeking in the title of the motion, post-conviction motions they were filing. So defendants would file this host of a motion to dismiss, a motion for a new trial, a motion for arrest of judgment. And the MAR, by enacting the MAR statute, the General Assembly said, we don't need you to identify the appropriate form of relief in the title of your motion and file separate motions. We need you to you can file one comprehensive motion that then asks for the various forms of relief that are applicable to the kinds of claims you are raising.
Generally, when we review a trial judge's decision on the remedies the trial judge is going to impose, is that not reviewed for an abuse of discretion?
So, Your Honor, I'm not aware of any case law in the MAR context that specifically addresses that issue. I do know the state cited a host of case law in both its primary brief and its reply brief, all supporting the proposition that when we're dealing with recantation evidence, dealing with claims of newly discovered evidence, and dealing with ineffective assistance of counsel, there's multiple cases that say the remedy for that claim is a new trial.
Okay, but generally, there's a factual determination the trial court had to make, correct? The credibility of the witnesses, for example.
Okay.
So we're not here finding facts. We're reviewing what the fact finder did, and we're bound by those, correct? We're bound by their credibility determination.
Well, there's case law that supports that a credibility determination is reviewable on appeal for an abuse of discretion.
Right. So it's also true that we're bound by the facts the trial judge found if there's evidence to support it.
That's correct, Your Honor.
Okay, so again, I go back to what this court's role is in reviewing what the trial court did.
Yes, Your Honor, and I think here what the trial court did in ordering dismissal of charges, that is legal error. that is reviewable by this court, right? That has nothing to do with the trial court's findings of fact. That has to do with the procedurally correct remedy for the kinds of claims these defendants were raising was to grant a new trial.
And you saying that that remedy the trial court gave is not permitted within the post-conviction MAR statute?
Applicable to the claims these defendants raised, right? So that there are circumstances in the MAR context where dismissal of charges is an appropriate remedy. And a classic example of this is if you look at 15A 1414, so a motion for appropriate relief filed within 10 days after the jury enters its verdict. Those subsections specifically say that a defendant at that point in time in the MAR context can raise essentially claims asking the court to dismiss charges based on any of the reasons cited in 15A 954, which is our statute governing what kind of issues a defendant can raise that may warrant a motion to dismiss charges. These claims that were in front of the trial court here are not claims that justify dismissal of charges. And the state's position, in addition to the statutory scheme of the MAR statute, there's an absurd consequences argument in this case. Whereas if the mere fact that 1417 identifies dismissal of charges as one potential remedy in the MAR context gives a trial court unfettered discretion to decide whether to impose that remedy regardless of the nature of the underlying claims.
But don't we have to have faith that our Superior Court judges are hearing the evidence presented in the MAR, finding facts based on that evidence, and then weighing that, in this case, not simply just recantation, but other claims to support overturning the convictions or newly discovered evidence, Harbison issues, recantation, and weigh all that together and make that determination based on the discretion the statute gives the Superior Court.
Respectfully, Your Honor, the state disagrees that the statute gave the trial court discretion to do that here. So although, of course, we want to say we trust our Superior Court judges can legally err.
So where does the statute, I mean, this is statutory, where does the statute limit the trial court's discretion to determine the appropriate relief in a certain situation?
Your Honor, so if you are asking me for is there language in 1417 that says the court couldn't do this, I don't think there is language, right? But I think this court has to consider the fact that even in the commentary to 1417, it explains that the point of the trial judge's role in the MAR context is to identify the form of relief that is appropriate to the claims raised. And the state cited in its brief State versus Whitehead, which is the North Carolina Supreme Court, where the Supreme Court ruled that although 1417 identifies correction of, say, sentencing errors, one form of relief available, the MAR court granted a form of sentencing relief that was not appropriate to the claim raised. And the North Carolina Supreme Court said that was error. So we have binding precedent from our North Carolina Supreme Court that supports that 1417 isn't an unfettered grant of discretion to a trial court. The trial court has to limit the nature of the relief granted to the nature of the underlying claim raised.
So go back to my question. The state is proposing that the proper standard of review before this court would be a de novo review of the trial court and not an abuse of discretion.
I think that's correct, Your Honor, because the state is submitting that the grant of relief here deals with a form of legal error.
I do want to get into the motion to dismiss the appeal and the argument being double jeopardy concerns preclude this court from even being able to review because the MAR functioned as an acquittal.
Correct. Yeah. So the state's position is that the trial court's ruling in this case was not a judicial acquittal. In essence, the only way that after verdict, if you have a judicial acquittal, that has to be based on a claim that the state presented insufficient evidence at the time of the original trials. And here, defendants' 2023 MARs do not include claims for insufficiency of the state's evidence presented at the 2004 and 2005 original trials of defendants.
The state's arguing also that this could have been raised earlier, correct?
Is it your initial position, I guess, or the first line is that everything's procedurally barred except for the recantation claim?
Those are arguments the state has set forth in its brief, Your Honor.
Okay.
That's correct.
And you're saying that our state is to narrow it down from Judge Tyson's questions. Is it fair to say you're saying that one standard there is de novo?
Applicable to the recantation? I think the state concedes that the recantation is reviewable for an abuse of discretion.
Okay. All right.
All right, let me ask you, there was another claim from the defense that false juvenile testimony, the testimony regarding that was a procedure that was not available to the defendants when the earlier Marr claims were raised. Do you want to comment on that?
Can you clarify that question, Your Honor? I just want to make sure I understand.
One of the theories that was presented was that the trial counsel's duty originally would have been to try to determine whether or not the testimony from the witnesses were subject to, that he should have gone out and gotten expert testimony to testify that juveniles do not tell the truth, basically.
Are you talking about defendant's ineffective assistance of counsel claims?
Well, that's one of it, but it's tied to the fact that the technology or the theory that that's true. There was no expert testimony available to defense counsel at the time, either during the original trial or when the earlier Marrs were issued. And therefore, it should not be barred. Not just the recantation, but the other basis for the Marr as well.
Your Honor, so my co-counsel is intending to address newly discovered evidence and the ineffective assistance of counsel claims, so I will let him address that. I will just briefly mention that at Mr. Banner and Mr. Coffin's trials, their attorney did attempt to put on an expert, Solomon Falero, who testified about the science of false confession, or was intending to testify about the science of false confessions, and the trial court held that that testimony was not admissible because it was unreliable. And that issue was fully litigated on direct appeal, and this court held that there was no error in the trial court prohibiting that testimony at the time of the original trial.
But wasn't the theory of that further developed, or the acceptance of that as a basis, did that not occur after the juvenile's trial and after the prior Marrs had been filed?
So, Your Honor, the state's position, as Mr. Vlahos will further address, is that scientific research and evidence was available, sufficient that the defendants could have made that argument following the time of their original trials.
Thank you. Okay.
Judge Hampton, just briefly touching back on the motion to dismiss and the state's right to appeal, I just wanted to point out that, again, the state is asserting this statutory right to appeal based on 1445A1, which says when there has been a decision or judgment dismissing criminal charges as to one or more counts, the state has an automatic statutory right to appeal. And the state submits that that is the form of relief the trial court ordered here, which then invoked this statutory right for the state to appeal. And in State v. Carver, a 2021 opinion from this court explained that although typically in the MAR context, 15A 1422 says that any appeal in the MAR context is by petition for writ of certiorari if there is not a direct appeal pending. In Carver, the court clarified that the state's statutory right to appeal in 1445 exists outside of that 1422 statute. So the state, if it has a right to appeal under 1445, it doesn't matter whether that comes before trial, during trial, in the context of post-conviction MAR proceeding, the state asserts that it has a right to appeal.
But you would concede that there would still be potential double jeopardy concerns, subject to double jeopardy, that right to appeal, of course.
So potentially, Your Honor, yeah. So if there was, say, if in the 10 days after trial, the defendant had moved for insufficient evidence to support the verdict, and the MAR court had looked at that and said, yes, there was insufficient evidence presented at those trials, then jeopardy is implicated. But here, that's not what you have. You have no finding based on the sufficiency of the state's evidence. And in addition, because once a new trial is ordered or a verdict is vacated, we return to a pre-trial posture where jeopardy is simply not implicated until a new jury has been impaneled. So for the trial court here to say, well, I know I can define precisely the scope of what the state's evidence will be at any retrial, That's speculative. That's not something the trial Judge Brody, at the time he issued that August 2025 ruling, doesn't have a crystal ball and can't define with any certainty what the state's evidence would be at retrial. Now, to be clear, there are protective mechanisms in place once a new trial, the proper remedy here, is ordered to allow, if the state's evidence at that retrial is insufficient, there are mechanisms for that review to happen, but it needs to follow the proper process, right? So the case would go back, the elected district attorney would have the opportunity to review the evidence they have to decide whether or not to pursue retrial. And then if that retrial occurs, once the state's case and the state's evidence has been defined in that retrial context, the defendant could again move to say the state hasn't presented insufficient evidence at this trial, and the trial judge at that point could assess the scope of the state's evidence. The state's position here is simply that the MAR court jumped the line. They made a ruling about what the state's evidence would be at retrial before that evidence had been defined, and that went outside of the court's authority.
Well, and I think the state's also arguing that the decision to retrial or not would rest not with the trial court, but with the elected attorney.
That's correct.
So he could have maybe dismissed, but then the district attorney could bring on for retrial.
That's
I
correct.
think what you're arguing is with prejudice. Is that correct?
I think, Your Honor, just dismissal of the charges, right? The proper remedy here would be to order a new trial, at which point it's the role of the elected official based on his or her constitutional authority to decide whether or not to pursue that retrial.
So it's not just with prejudice, it's the dismissal itself.
That's correct, Your Honor. Your Honor, if the court has any specific questions about the state's argument on Jessica Black's recantation, I'm happy to address those. Otherwise, I will turn this over to my co-counsel to address the IAC and newly discovered evidence claims.
Okay, thank you.
May it please the court, as Ms. Williams said, I'm Nick Blahos. The MAR court erred in concluding that advancements in adolescent development science and false confession research were not in existence at the time of trial because a record shows that pretrial and post-conviction experts relied on the same or similar adolescent characteristics and interrogation techniques to form their opinions about the reliability of defendants' confessions. According to State v. Nickerson, newly discovered evidence is evidence which was in existence but not known to a party at the time of trial. The record shows that the characteristics and techniques relied upon by the experts in this case were not only in existence at the time of trial, they were known to counsel for the parties. First, defendants Banner and Coffin attempted unsuccessfully in their trial in 2004 to present expert testimony about the psychology of false confessions, including false confessions of juveniles, or false confessions by juveniles. The exclusion of this evidence was upheld on appeal by this court. While defendants Banner and Coffin exercised due diligence to present the expert testimony at trial, they did not employ proper means, and the evidence was excluded. Okay? Second, trial counsel for defendants Tolliver and Bryant testified at the MAR evidentiary hearing that they considered using a false confession expert at trial, but decided not to do so because they believed it would not be helpful to the defense and due to the nature of the coercion that they perceived against their clients as being so explicit. That's why they made the decision. That's what they testified to at the MAR hearing. Consequently, the record in this case shows that due diligence and proper means were not employed to procure the expert testimony at trial, and the claim fails, or should have failed, the prong of the test for newly discovered evidence set forth in State v. Beaver.
Why wouldn't it be law of the case? If the issue was raised and litigated, excluded, and was affirmed on appeal related to the same incident parties, why would that not be the law of the case?
Well, you'd think it would be law of the case, Your Honor, but I don't know. This was a different set of experts, and they took a different angle and approach, but their angle and approach was not that different from the approach the pretrial expert did. So,
Do you know if the state raised that at the MAR hearing?
yes, Your Honor,
This is already settled. This was a settled issue.
Yes, Your Honor, they challenged the experts when they called them to testify, objected to their testimony, and the MAR court ruled that their testimony could be admitted.
Right, but again, were they challenged on the basis that this is like a ask and answered objection, that we've already been through this, it was ruled excluded, the appellate court ruled on it, we don't need to go back there?
I don't know the answer to that question, Your Honor, but I know they were challenged based on the science. I apologize, I misunderstood the question.
Thank you.
Additionally, the record shows that the alleged advancements argued by defendants are not newly discovered evidence, but newly created evidence. So the claim fails, or should have failed, on the prong of the Beaver test, requiring evidence of such a nature that a different result will probably be reached at a new trial. So that's two prongs of the Beaver test that the evidence fails. It also means that the claim is procedurally barred under General Statute 15A 1419A, pursuant to State versus Tucker, North Carolina Supreme Court decision holding that the MAR court correctly concluded that the Michigan State University RJA study was not newly discovered, but newly created when it determined whether the study was, when it determined that the study was insufficient to overcome the mandatory procedural bars of 15A 1419A. And a quote directly out of that case is, "We agree with the MAR court that allowing defendant to label such a study as newly discovered evidence sufficient to overcome a procedural bar would effectively allow defendant to manufacture a mechanism to file an infinite number of MARs." So that's the danger inherent in allowing that, Your Honor. So the question comes to be, what was the methodology of the experts pre-trial and post-trial, and what techniques did they look at, and how did they approach the problem? Well, first of all, none of the defendant's mental health experts met with or evaluated the defendants. Dr. Falero, who was the pretrial expert that Banner and Coughlin called, did not conduct any type of evaluation or examination on either Banner or Coughlin. Instead, his methodology consisted of reviewing statements, transcripts of hearings, and police reports from the case to form his opinions. Dr. Cleary, who was one of the post-conviction experts, did not meet, now she's a false confession expert, she did not meet with any of the defendants and did not evaluate them to determine whether they were intellectually disabled or suffered from any cognitive impairments. Instead, her methodology consisted of reviewing Dr. Calloway's 2022 testimony about her analysis of defendants' school records and case materials provided by the North Carolina Innocence Inquiry Commission. Dr. Calloway is another one, Dr. Ginger Calloway. She was the mental health expert. She never interviewed or met with defendants, did not diagnose them with an intellectual disability, did not speak with any of their family members, and did not contact any school psychologists who administered tests that were contained in defendants' school records. Instead, her methodology consisted of reviewing available records, including school records, recordings of transcripts of defendants' interrogations, and video recordings of the full 2020 Innocence Inquiry Commission hearings to form an opinion as to whether defendants had any sort of cognitive limitations. So their methodologies, pre-trial and post-trial, were very similar. None of them talked to the defendants, and these were all the defendants that trial counsel talked with at length so they could see whether they thought they were cognitively impaired, which none of the lawyers did, but the surviving ones. There was one that passed away. And so that kind of gets into the ineffective assistance of counsel side, but counsel also talked to their family members too, which none of these experts did, either pre-trial or post-conviction.
And the MAR trial court heard all of this.
It knew it, Your Honor, from the testimony.
That's right. It heard the evidence on this and weighed the credibility of that evidence and gave it the weight it felt appropriate and made its decision. I mean, if there's evidence to support the trial court's determination, what role do we have to simply throw out those weighing determinations?
Because the conclusions of law that it reached were erroneous. On the two Beaver standards that I mentioned, those are conclusions of law. So, in fact, most of the trial court's decisions are contained in the conclusions of law section. The MAR order reading it, it struck me while I was reading it that the statement of facts kind of reads like a recitation of facts. Not a lot of material decisions are made about the evidence that was presented, and so the legal conclusions come in. Now, to be fair, and I don't say that to be critical of the MAR court, but to be fair, the MAR court did put kind of catch-alls. If these are not findings of fact, they're conclusions of law, and if they're not conclusions of law, they're findings of fact. But The decision part is in the conclusions of law. That's where the focus is. So unless this court finds that there were really findings of fact, the conclusions of law reached by the MAR court are in error, and that's what the state's arguing here.
So you're saying the findings, if supported by evidence, or do not support the conclusions?
Correct, Your Honor. That's correct. And
we would review that de novo.
yes, Your Honor. That's absolutely de novo. Now, they also talked about the psychological literature on the subjects. Dr. Falero tested around that this had been around for basically over 100 years. He testified that the psychology of interrogations and phenomenon of false confessions dates back to the early part of the 20th century when books on the subject were published, and I think he said the first book was published in 1908. So we've had time for this science to mature for a long time. Now, surely, Dr. clearly testified that the body of literature surrounding the field of adolescent developmental psychology, psychology of interrogations and confessions, has grown and been refined in the last 20 years. So then the question becomes, well, how much has it grown? How much has it advanced? And were these techniques and ideas available at the time of trial the way they were at the time of the post-conviction hearing? And the state argues that they were, based on the evidence that was presented to the MAR court. They talked about juvenile susceptibility to false confessions. According to Dr. Falero, pre-trial, empirical data demonstrates that juveniles are more likely to confess to crimes they did not commit than adults. Dr. Clearly, post-conviction, similarly testified that research shows that adolescents as a group are more suggestible than adults. Dr. Falero, pre-trial, testified that research indicates that juveniles are more susceptible to rapport building and to all other interrogation techniques because they are more suggestible and more likely to confess.
And again, the trial court had all this information.
Yes, Your Honor.
And its determination and findings of fact. And I know you're kind of deep into your rebuttal time at this point, but and am I correct that the state put on no evidence at the MAR hearing?
That's correct, Your Honor. But they vigorously cross-examined the defendant's witnesses, including challenging the experts and challenging what they said. They also talked about juvenile escape strategies, which were similar pre-trial, similar to post-conviction, impact of self-incriminating statements on jurors. False confession experts made no credibility determinations. They're not saying whether the statements that the defendants gave are true or false. The interrogation setting, recognized interrogation techniques that they went over, and Your Honor, I see I'm going to go over time here. I'm going to leave the rebuttal, unless the court has questions about this or other ones.
Well, just in case your rebuttal runs short, what would you have the court do? What would the state's predator court be?
Well, the court would like, the state would like the court to reverse the trial court's order based on the DNA testing and based on all four of the claims, okay, because of errors. And it was a conclusions of law. If you look deeply at those, they don't align with Strickland. They don't align if you look deeply at them. But the other thing that the court can do is to grant relief on this. Your Honor mentioned it, the dismissed with prejudice. At the very least, the DA's office should be allowed to re-prosecute these cases if it seeks that they need to be. I mean, it's their constitutional duty to do so. And that's where the decision lies, not in this trial, not in the MAR court. Thank you.
Thank you. Evidence from the defendants. Good afternoon. Good morning. So I know you have multiple counts, so do y'all intend to divide your argument, or?
Your Honor, no. I'm going to be arguing with the permission of the defendants and co-counsel for all defendants in the case, okay, on all claims and the relief. May it please the court. My name is Brad Bannon. I'm here today with Christine Muma and Mark Rabel. Together we represent Christopher Bryant, Jamal Tolliver, Ray Sean Banner, and Nathaniel Coffin. As I said, I, with the permission of the defendants and their lawyers, will be arguing for all defendants in this case. I'd first like to address three issues, which are the recantation claim, the DNA claim, and the remedy of dismissal. But before doing that, I just want to direct the court's attention to the record at page 607, paragraph 52, where Judge Brody, the MAR court, expressly said, to the extent anything in the conclusions of law section may be a finding of fact, I'm incorporating it here into my findings of fact. That is, of course, consistent with case law, State versus ICARD 363 and C303, which says the labeling of a finding of fact or a conclusion of law doesn't matter. It's just what the substance of that is. So, beginning with the recantation claim, which the state has conceded is not procedurally barred in this case, Jessica Black testified at the defendant's trials that she saw and heard the defendants plan and carry out the attack against Mr. Jones, and that included hearing them talk about it, taking them to the store to get tape so that they could do it, taking them back to the scene, watching them walk over to it and pick up weapons, listening to them as they attacked Mr. Jones for 10 minutes, and then watching and listening to them as they came back and discussed it. The state at their trials told the jury, without her testimony, you know almost nothing about what happened that night. The trial court found in this evidentiary hearing, in this MAR, that she was the key witness of the state against the defendants, which is a fact that is not disputed before this court by the state. At the evidentiary hearing, Jessica Black testified for 6.5 hours before the trial court. 4.5 of those hours were under cross-examination. She recanted her trial testimony under oath for the 4th time in 7 years and admitted that she committed perjury at their trials. She told the trial court that she did not hear them talk about this attack. She did not take them to get tools to commit it. She did not watch them pick up tools and go over and commit the attack. She didn't listen to them commit the attack, and she didn't see them when they came back from the attack. Quote, those things didn't happen. The reason she said they did happen, she also testified to, which was coercive tactics that are known through decades of research to cause false confessions in juvenile suspects particularly, and the threat that she would be put in prison for the rest of her natural life if she didn't testify for the state.
What was her age at the time of testimony?
16. She was 16, Your Honor, at the time that, of the crime. I think probably by trial she might have been 18. The defendants themselves testified at the MAR evidentiary hearing about their interrogations, and their testimony was consistent with hers about the tactics that were used in their interrogations as well. The state called none of the officers involved in those interrogations, not one of the 17, in order to dispute any of the defendants' testimonies or Jessica Black's testimony about what happened during those interrogations. As a result, the trial court found specifically that her recantation testimony was credible and expressly rejected the state's attempts to impeach her. Both of those findings are in the trial court's order, including the rejection of the attempts to impeach. The trial court also found that newly discovered exculpatory DNA evidence supported her recantation, as did juvenile false confession science, which showed that the defendants did not commit the crime and the high probability that their confessions were false. The state called no experts to dispute any of that testimony. The trial court found, as it is required on this claim, that it was reasonably well satisfied that her testimony against the defendants was false. And because she was the key witness at both trials against them, there was a reasonable probability, not just a possibility, which is the standard under Britt, but a probability that there would have been a different outcome at their trials. That was supported by competent evidence and is reversible only on a showing of manifest abuse of discretion.
Am I correct that the state agrees with you that this recantation evidence was new evidence and was not barred by the previous Mars?
Yes, Your Honor.
So,
I believe they've conceded that at both the evidentiary hearing level and here in this courtroom today.
So if that's not an issue before us, that basically it was new evidence and it was proper for the trial court to consider that, from what I heard from them is they are disagreeing with the remedy that the trial court, the relief the trial court gave, and the dismissal with prejudice. And I don't want to frame your argument, but I want to try to get to if there's no disagreement with the state that this was proper new evidence, then I think we all agree with that, right?
Yes, Your Honor. And let me make clear, you can frame my argument all you want. I'll answer whatever question you have.
I just wanted to make sure that, you know, if that's not an issue before the court, that the state's conceded that it was new and it was proper to be brought at this time, then we're going to take that for what it is.
The state's position is if that claim is upheld, this court should grant a new trial rather than a remedy. The defendant's position, rather than a dismissal. The defendant's position, which was the trial court's position, is that a dismissal with prejudice is appropriate, and I can go ahead and address that right now as well. In this case, the trial court conducted a 3-week evidentiary hearing. The defendants called 19 lay and expert witnesses and introduced 100 exhibits in support of their claims. There are 10,000 pages of this record that the trial court reviewed. After all of that testimony and evidence was introduced at the hearings, the parties had closing arguments during which the trial court actively probed the parties on every single claim that was before it. The claims that the trial court granted were all substantively related to the guilt of these defendants. The first was recantation, saying that the only evidence, the key evidence against them at their trial, was no longer credible. There was also DNA evidence that they did not commit the crime. There was actually multiple DNA profiles found on one of the murder weapons that excluded them as the contributors. There was also juvenile false confession science that the court heard 7.5 hours of testimony about from Dr. Cleary and several hours more from Dr. Calloway that showed the high probability their confessions were false. And the trial court found ineffective assistance of counsel based on counsel's best and their trial counsel's failure to meaningfully challenge that.
Did the DNA evidence exclude them, or did it just show that it wasn't there?
It excluded them, Your Honor. So and that's an argument that I think kind of goes a little bit into the DNA argument, but I'll address that right now too, which is that there were 21 crime scene items that were seized post-conviction and submitted for testing. On most of them, there was not enough DNA to actually develop a profile to compare, which is a different situation than saying there was DNA on it that the defendants could not be excluded from. That's a totally different thing. What happened with most of those items is there just wasn't enough DNA to test. But on the murder weapon, which the state alleged the defendants went to the store and picked up the tape that was bound around Mr. Jones's hands during a violent struggle, there was enough DNA to develop multiple people's profiles. One of them was a major female. The other were 2 minor males, one of whom was likely Mr. Jones, the other of whom excluded all of the defendants in this case. As a result, the trial court found that compelling evidence that they did not commit the crime. And that finding supports, of course, not just the recantation claim, but the dismissal remedy. That evidence went virtually unchallenged by the state at this hearing. I heard mention that they made efforts to try to impeach witnesses. Those efforts obviously failed because the trial court credited the testimonies of the experts and the lay witnesses who testified, as was the trial court's responsibility and role under the law. Once the trial court heard all of this evidence and understood there were 2 pillars of prosecution against the defendants, which were Jessica Black's testimony and these confessions, the trial court understood that the state could no longer rely on Jessica Black's testimony at a new trial. Clearly established law says they will not be able to call her to testify against the defendants. That leaves the confessions, which the trial court obviously found were discredited by decades of research on juvenile false confession science that both Dr. Cleary and Dr. Calloway supported. And I'd like to say something about that for a second if I can, given what I heard. There are objections being made in this courtroom, I think, to the foundations of some of the testimony, to some of the facts underlying them, maybe even to some of the science. The state made those challenges at the trial court level, and those challenges were rejected. They did not raise those rejections as an issue before this court. With respect to the juvenile false confession science, the only thing they raised with the court was whether that was new evidence to support the newly discovered evidence claim. So, with the confessions discredited effectively through actual proper application of effective assistance of counsel under the science, the trial court found there was no path to retrial and conviction beyond a reasonable doubt. And I want to speak for a moment to its authority to do that. That authority is clear under the statute. It's right there. It is not constrained in any way by the statute. It's been there for 50 years. Article 89 has been amended. I'm sorry, that's the motion for appropriate relief statute. Article 89 has been amended many times over the last 50 years. Section 1417 itself about the remedy has been amended, and in none of those amendments has the General Assembly ever cabined the dismissal remedy to any particular claim or fact pattern, and no case of this court or the Supreme Court has ever held that. The cases cited by the state simply stand for the proposition that in those particular courts, those remedies were either appropriately granted, or appropriately denied in those particular cases. There is not a case that stands for the proposition or has ever held that dismissal is an inappropriate remedy for any of these claims, or that a new trial is the only appropriate remedy for any of these claims.
So the state noted the Whitehead case.
Yes.
How do we distinguish that, or can you distinguish that?
State versus Whitehead, the fact pattern there was that, you know, we had the Fair Sentencing Act and the Structured Sentencing Act, and the defendant had committed his offense and was sentenced under the Fair Sentencing Act. Then the Structured Sentencing Act was passed. The defendant filed an MAR, said, I'd like to be resentenced under the Structured Sentencing Act because if so, I'd be able to get out of prison right now. And what the court held in that case was, and the trial judge did that, but what the court held in that case is the trial judge was prohibited from doing that because the Structured Sentencing Act statute expressly prohibited the trial courts from going back and reimposing fair sentencing on a structured sentencing defendant. So there was an express provision in the statute saying you can't do this. Here, it's the opposite. There is an express provision in the statute saying you can do this if you find it to be an appropriate relief. And something else that's important about the Whitehead case, which I might as well get out of the way, is that it addresses the separation of powers between the judicial branch, the executive branch, the legislative branch. And it makes very clear that district attorneys' authorities and judges' authorities are limited and constrained by the legislature, which has the express authority to set the penological system of this state. There are plenty of areas and plenty of ways in which the discretion to try or not try or dismiss or not dismiss is constrained by statute. This is not one of them.
It's also constrained by the Constitution of the state too. Would you agree?
Yes, Your Honor. And that was the basis for Justice Martin's decision in that case was, you know, we have this pretty clear provision in the Constitution about the separation of powers. Therefore, trial court, you can't, you know, the legislature constrained your ability to resentence this defendant by putting expressly in that statute, you can't resentence that defendant.
I'm going to take my shot at reframing your argument, but what I'm kind of hearing, though, is, you know, there are these sort of separate silos of the arguments, right? There's the recantation, there's juvenile false confession, there's DNA evidence, there's ineffective assistance of counsel. But the way I think I heard you articulate consideration of all this is that the trial court's not looking at any one of these in silos. It's considering the recantation, which was the trial court felt was consistent with the DNA evidence, which the trial court felt was consistent with the juvenile false confession evidence, along with the ineffective assistance of counsel in determining and fashioning what the appropriate remedy is.
Yes, Your Honor. I mean, it's very clear from the decretal section that he doesn't, you know, tick through on this I'd do that, on this I'd do that. What he says is, based on the strength of all of this evidence that's been presented, I'm dismissing this case, which is his right to do under the statute and which is supported by the record in this case. You know, I've heard that, I think one of the arguments was that the defendants had not identified the relief that was requested in this case, but they actually did. And if you go back and you read their MARs, their primary request for relief was dismissal of these charges, which of course the state was on notice of during this hearing. You know, I think the state referred to this statutory construction argument that if a statute is going to result in absurd consequences, it should be struck down or modified in some way. First of all, that's, as the court knows, you don't get to that level of statutory construction analysis until language is unclear or ambiguous in a statute. We submit it's not unclear or ambiguous, but on this record, which Judge Hampton just sort of recounted and ticked off, we have a scenario where there were all of these substantive claims that were grounded in their guilt. There were 19 witnesses that were called to support that evidence. The trial court deliberated for 6 months over it and entered a 115-page order with 33 findings of fact and conclusions of law and 83 pages of attachments incorporated into those findings of fact by reference. The trial court expressly noted in its order that the state failed to call any witnesses to dispute the claims. The trial court expressly noted in its order that it rejected their attempts to impeach or discredit Jessica Black. The trial court found newly discovered exculpatory DNA evidence that supported their claims and that the advancements in the juvenile false confessions did. With that record and no sufficient path to retrial beyond a reasonable doubt, there is nothing absurd about that. It's supported by the statute. It is measured by this court against whether it was such an arbitrary decision that it could not have been the result of a reasoned decision. And I submit when you look at the order, it's quite clear the reasoning that occurred in this case, and it's supported by the record.
One thing I was thinking about during the argument, basically, you got a right to ask for dismissal at the close of the state's evidence in any criminal case and not let it go to the jury. And the trial court can award that, right?
Yes, Your Honor, based on the sufficiency of the evidence. And that's what defendants submit. This was a sufficiency of the evidence decision. I mean, you can't look at this order and see what he went through, see what he considered, see what he found, see what claims he granted, and not come to the conclusion that this was based on his knowledge of, in effect, if I sent this back to a trial court at this point, what would it look like? They cannot use Jessica Black anymore, who was the key witness against them at their trials. That literally means the only thing left is this confession evidence, which was not meaningfully challenged at the trial court level. And it dovetails a bit, Your Honor, with you mentioned law of the case, which is because, there certainly was a motion to suppress in this hearing, and that motion was denied. Obviously, if that motion was denied based on ineffective assistance of counsel and litigating it, it's unlikely that that would remain the law of the case here in this particular case. And that, of course, is the foundation of the ineffective assistance of counsel claim, is that the confession evidence was one of the two pillars of evidence against these kids at their trials. All of the defense lawyers filed motions to suppress on voluntariness grounds because they appreciated the importance of that evidence. And then they did nothing to address what this court, or what the Supreme Court found in State versus Dawson almost 30 years earlier, were the important factors in that test, which were education, intellectual ability to understand the impact of the statements that you're making. They did not go get their school records, which would have been the easiest thing in the world to do, and they could have done secretly, because that's what you can do as a defense lawyer, and you could have gotten ex parte assistance through the courts, because you can do that as well when you're developing a defense. And if they had gotten those school records, they would have seen on their face evidence that all 5 of these kids had severe cognitive impairments that put them in the lower 2 to 14% of intellectual functioning for their age range, or in the intellectual functioning range of elementary school children at the time of their interrogation.
Now, I believe the state argued during their argument that was presented before the trial court originally, that testimony was excluded, and that this court or the Supreme Court upheld the exclusion of that evidence. And this goes more to the IAC claims, in trying to paint the original trial lawyers as incompetent. in providing ineffective assistance. If they did that, if they tendered it and it was excluded, and that exclusion was upheld on appeal, how is that ineffective assistance?
Your Honor, it's because that's not exactly what happened at the trial court level. What happened at the trial court level is that Teresa Heyer, who was there were two trials here, and Teresa Heyer was Nathaniel Coffin's lawyer. What she did is she did go out and hire a false confession expert named Solomon Falero.
Right.
What she did not do was have her client evaluated, obtain their school records, or provide any of that information to Dr. Falero. And if you look at Judge Albright's order, which is in the record, in which this court reviewed on appeal, he did not categorically exclude false confession expert testimony. He excluded the false confession expert testimony proffered from Solomon Falero because, you can see this right there in the ruling, Dr. Falero did not have information about the individual defendants to which he could apply this science. So literally, in many respects, the exclusion of Dr. Falero at the first trial sort of proves the IAC claim, which is if they had gone out and gotten this information and given it to Dr. Falero, he could have been able to testify. And that's what this court found on appeal of that order. It didn't say, you know, this is unreliable science. We're not getting into it. It said because, you know, the trial court did not abuse its discretion when it found that Dr. Falero had not been given any information about these individual defendants or the tactics used to interrogate them or how the latter applied to the former.
Now, the state's arguing that your experts did the same thing. They never even talked to the defendants. They didn't go back and get the records. So, I mean, if it's ineffective for the original expert to have not done that, the state's saying your experts didn't do it either.
Again, if I can just clarify the record a little bit, they certainly did review the school records of the defendants.
They didn't talk to the defendants? No.
And there was testimony at the trial. Of course, under Rule 702, what experts rely on isn't necessarily things that they've observed themselves, but things that other people have observed that people in their line of expertise regularly rely on. There was sufficient foundational testimony at the hearing to show that that's exactly what they did, and that it would have been inappropriate. I mean, it was 20 years later. It would have been inappropriate for Dr. Calloway to go back and try to interview defendants 25 years later to develop some kind of an assessment of them, you know, back then. But what she could do, and what her area of expertise allows her to do, is look at the contemporaneous evidence of what their cognitive impairments was and explain that to the fact finder, which is what happened here. And Dr. Cleary testified very clearly that she is a research psychologist, not a clinical psychologist. Clinical psychologists are the ones that actually are qualified to assess and conduct interviews and conduct testing. They create their results, and then they're given to experts like Dr. Cleary, who rely on them routinely. And again, these arguments were made before the trial court, Your Honor, and the trial court's rulings on them are not challenged here as a matter of the briefs that have been filed and the issues that have been raised by the state.
Why are these IAC claims not barred by the prior MARs?
By the prior?
Yeah, not worried about the direct appeal, but focused on the prior MARs.
Some of it depends on which IAC claim it is, but very broadly, as it relates to the MARs, you had two sets of MARs. The first was filed in 2008 by Christopher Bryant. That MAR was...
It was a pro se MAR too.
It was a pro se one, Your Honor. Chris was in prison, and he testified to this. It's in the record. He was in prison. He tried to get lawyers to help him, nonprofits to help him. He couldn't get anybody to help him. Prisoner Legal Services sent him a blank form, a blank MAR form. He asked somebody in prison to help him fill it out. They did. He mailed it in, and that was that. At the time, he had an 8th grade education. He had been assigned to educational programs in the prison system for 6th graders. He was severely cognitively impaired, and the court did not appoint any counsel to review the MAR, amend it, assist him in litigating it. So literally he was imprisoned, indigent, severely cognitively impaired, and not in any position to adequately raise any claim, whether it was false confession science, ineffective assistance of counsel, let alone an adequate position. With respect,
How does that change the procedural bar?
Well, the procedural bar asks whether a defendant is in a position to adequately raise a claim. And based on where he was in his time, in his mind, mentally in prison, without counsel, without resources, defendants submit without being appointed counsel to assist him in that he was not in a position as a pro se litigant to adequately raise and litigate that claim.
That same claim can be made of any pro se motion, Mar, that this court or they get from an inmate. Sure.
I don't know every case that upholds this. I don't know that there's the fact pattern that's similar to the one that Mr. Bryant experienced. I certainly know that there is precedent for the fact that just because it's a pro se MAR doesn't mean that it's not subject to a procedural bar. Absolutely the case. What I would argue here is that in this particular pro se MAR, the procedural bar doesn't apply because of his unique situation and circumstances in which he sent in that form.
And the trial court made a determination as to that.
Yes. Obviously, so moving on to, I want to address the Banner.
Now, on appeal, would this court look at that decision de novo, whether or not it did bar?
That's a great question, Your Honor. I'm not entirely sure whether that would be a question of fact, question of law, or a mixed question of law and fact. I think that if this court found it was a question of law, of course it's a question of law that you would review de novo. I think whatever facts are underlying that question, of course, are not objected to here and are deemed to be supported by competent evidence and binding on this court. With respect to Rayshawn Banner and Nathaniel Coffin's MARs, they were, if you look at them, they were limited. In effect, they were remedial MARs based on the Supreme Court's decisions on Miller and Graham and the related statutory, the related statute that was adopted by the General Assembly that basically said juveniles who receive sentences of life without parole can no longer be held under life without parole sentences. And so those juveniles were resentenced as a result of that litigation. And the position of defendants, of course, is that's not and never has been deemed to be a procedural bar under the law. I have about 60 seconds. Unless the court has any other questions that I can answer in 60 seconds, I will just rest on the remaining arguments on the brief.
Do you want to address the double jeopardy issue in your motion to dismiss the appeal at all, if you can do that in 53 seconds?
If I can do that in 50 seconds. Okay.
We'll be lenient with your time as we have
Thank
with the
you, Your
start.
Honor.
So.
Double jeopardy, of course, looks to whether, in this particular context, I'll cut to the chase. The question is, was the dismissal with prejudice a judicial acquittal? If it was a judicial acquittal, then the remedy the state is seeking here today and saying the only remedy, if any of these claims is granted, is a new trial. A new trial would subject these defendants to double jeopardy, and it's therefore barred under the statute. There were, I think the state emphasized in its filings, and I think maybe in its argument, this question of timing. Like, is this a pre-verdict versus a post-verdict ruling on the sufficiency of the evidence? And of course, we would obviously argue, for the reasons I previously argued, that the dismissal with prejudice was a sufficiency of the evidence ruling, and that with prejudice, which are words that were very intentional and which are known to be words that end litigation, the question then becomes, is that Is the timing of that somehow prohibited by the case law? And I would say no, because the case law about pre-verdict versus post-verdict timing is only in the context of a motion to dismiss at the trial level. And what's important about it is, if the trial court grants that motion pre-verdict, then reversal would require the defendant to defend themselves again. If it's a post-verdict motion on the sufficiency of the evidence, then reversal would not require the defendant to defend themselves again. It would just restore the verdict that was already there. Here, as I said, reversal of the dismissal in this particular procedural context, if the state gets what it wants on the remedy of dismissal, which is a new trial, that would literally be asking for the thing that double jeopardy prevents, which is a second trial. I understand before I sit down that they're contesting the substance of the claims as well, but we only get to this question if the court upholds the claims and is ruling on the remedy. So I hope that was worth the time.
We thank you. And what would you have the court to do?
We would have the court uphold the trial court's order,
In its entirety.
In its entirety. Thank you for your time.
Thank you, sir. Rebuttal? Mr. Sewell, would you please give them 3 minutes?
Ms. Williams, I'm going to jump out the front here before the clock even starts. I want to hear from you. You can argue whatever you want, but I want to hear from you about why you think the trial court's reliance on the recantation was an abuse of discretion.
Of course, Your Honor. So I think there are 5 points about why the trial court's crediting Ms. Black's testimony constitutes an abuse of discretion in this case. First is that Black's testimony at the MAR evidentiary hearing regarding the events of November 15th, 2002 was inconsistent with defendant's own testimony at the MAR evidentiary hearing. It was also inconsistent in many ways with her testimony before the NCIIC. Second, Black's recantation testimony was highly equivocal. She repeatedly testified that she couldn't recall the events surrounding the circumstances of the murder due to the passage of time, due to her own efforts to suppress her memories. Third, Ms. Black had a clear motive to lie in this case, out of her own self-preservation and protection. Her testimony merely minimized her involvement in the offenses. She testified repeatedly at the MAR evidentiary hearing that at the time of these original trials, she received threats, including death threats, and in the years that followed, there were portions of Winston-Salem she wouldn't visit because she was afraid for her safety, and I think it's telling that her recantation only came about shortly after 3 of the 5 defendants were released from prison. Fourth, Black only produced her recantation in response to calls from a reporter, and this reporter at the time bought her food, bought her a birthday cake. The record also showed that this reporter paid her car payment while she was homeless and living in her car, so it's essentially paid money for her to maintain her housing situation at the time she first produced this recantation. And I also think the recantation and all of the circumstances surrounding how Ms. Black made this recantation has to be compared and contrasted to her original statements. So that's the 5th point. The record reflects that Ms. Black came forward of her own voluntary volition to the police 4 days after the murder occurred, and within a 2-hour period gave a statement, a 30-minute statement that gave incredible amount of details about how these defendants committed this murder. She then gave trial testimony at 2 separate trials that was consistent with her 30-minute statement to the police. She was subjected to extensive cross-examination at the time of that original testimony, and for all of those reasons, the state submits that the trial court's decision to credit her testimony was an abuse of discretion, particularly where the trial court made no effort to explain these weaknesses or discrepancies in its order. Finally, as just a closing point, Your Honor, I want to go back to the remedy piece of it, because I think that's a judicially significant, jurisprudentially significant issue in this case. Again, the mere fact that 1417 identifies dismissal as one form of remedy available in the MAR context does not mean it's available to every form of claim. I think it is telling in this case that although the MAR statute has existed since 1977, defendants have cited not even one single case, not one single instance of precedent where a trial court in response to claims of newly discovered evidence, recantation evidence, or ineffective assistance of counsel ordered dismissal. It was the wrong choice of remedy in this case. For these reasons, the state asks this court to reverse the trial court's ruling, or in the alternative, at a minimum, to order the only appropriate remedy of a new trial. Thank you.
Thank you. Let me ask you one last comment on the IAC. Can you just make a closing comment on the IAC claim?
Is there one of the specific claims, Your Honor, that you are interested in?
Basically, whether or not original trial counsel's efforts and what they did was sufficient representation.
Your Honor, I think it was sufficient. It was sufficient. They attempted to produce an expert to talk about the science of false confessions. Also, one clarifying point, I don't have the record page in front of me, but if you look at the trial court's ruling excluding Falero's testimony at the time of Banner and Coffin's trial, the trial court did specifically rule that the science underlying that testimony was unreliable under 702 and 703, and that was the basis for its exclusion, which was then affirmed on appeal. So it wasn't the mere fact the expert hadn't considered the defense, it's that the underlying science was also unreliable. Thank you, Your Honor.
Okay. Thank you very much for the good briefing and the good arguments. The case is submitted, and Mr. Zor, will you please adjourn court?
All rise. The session of the North Carolina Court of Appeals is adjourned.
This room's